we are going to be full in more time. Let's just wait for 20 more seconds for everyone to join in. Here we go. It's an extra special webinar for two reasons. One, the much anticipated Apex Court judgment in the MFN matter is out. It's been almost 10 days now since the judgment has been delivered, and we've all, over the passage of time, the emotions come down a bit, and logic and analysis takes over. In the immediate aftermath, the emotions run high, as we saw after Azadi, as I distinctly remember after Vodafone. I would like to remind all our viewers that last week we did say the troika of Supreme Court judgments. In the early 2000s, we had Azadi, which made waves internationally. One line, I recollect, and I did mention this in CNBC in 2004. One line from the Supreme Court judgment, they said, a double tax treaty may be a necessary evil for a developing economy. That's the line I remember. In 2012, Vodafone judgment came early 2012. And that judgment propounded the look-at theory. They distinguished look-through from the English courts and said, we will go by the look-at theory and discharge Vodafone from any tax liability whatsoever for the $2 billion purchase of Hutchison in India. Hutchison did not have to pay tax. Vodafone consequentially did not have to deduct any tax. That judgment was one of the most controversial judgments ever rendered by the Supreme Court in post-independent history. Be that as it may, it led to a lot of consequences, retrospective amendments, and finally undoing of that retrospective amendment a couple of years back. Now, 10 years later or 11 years later, we have another judgment which is path-breaking, landmark, extraordinarily important as Vodafone and Azadi when it comes to tax treaty interpretation for international tax professionals, for connoisseurs of tax law. Extraordinarily important judgment on MFN. And what did it say? It said essentially that a notification under Section 91 of the Income Tax Act is necessary and a mandatory condition for a court, tribunal, or an authority to give effect to a DTA or any protocol changing its terms that has the effect of altering the existing provisions of law. And the Supreme Court has left no ambiguity. They've relied on several past precedents, the Vienna Convention, so on and so forth, and essentially rejecting all the assessees' arguments. They have said that when it comes to treaty enforceability, only signing of a treaty is not enough. It does need to be notified. They have quoted from Magan by Ishwarbai and said that it's a well-established rule that the making of a treaty is an executive act, while the performance of its obligations, if they entail altering of the domestic law, requires legislative action. Huge ramifications of this judgment. The man in front of us is the man who's the giant killer. He's the man now for all seasons when it comes to the cases for the revenue. I distinctly remember one of the senior advocates who spoke at the Taxsutra conclave on day one. And of course, Venkat's headline day two, day one evening, said that the pendulum seems to have swung towards the revenue. The man in front of us, Additional Solicitor General of India, Sri N. Venkataraman, is a man singularly responsible for the swinging of pendulum from the taxpayers' favor to the to the revenues' favor. The pendulum has swung, and how? If there is one sobriquet to be given to Venkat sir, he is absolutely a giant killer. You look at the case relating to the exemption of trust, to the capital versus revenue matter on variable telecom license fee expenditure, where again he won in a batch of cases, a big matter, and now the MFN one as well. These among a dozens of cases that he's argued. And prior to that, let's not forget, for over 3 decades, he has represented the taxpayers in thousands of matters, laying down jurisprudence on important indirect tax matters, on international tax matters, transfer pricing cases, you name it, and he's done that. And over the last 3 years as an additional Solicitor General, quickly, just in 10 seconds or maybe half a minute I'll spend to take you through the cases that he's represented. Google matter in the NCLAT, where NCLAT ruled in favor of the Competition Commission. That is now before the Supreme Court. But Venkat sir successfully represented a Competition Commission before the NCLAT against the Google. He's represented the union in leading tax matters, international arbitration matters, IBC matters, leading matters under Competition Act, environment, domestic arbitration, telecom, and energy matters, besides advising the government on various international agreements and transactions relating to investments. His first love is indirect tax and GST. So the matters that he's argued on GST include VKC footsteps, Mohit Minerals. I loved reading that case. A role of GST authorities on approval of classification and its arbitrability, DPB scripts, tobacco batch, and the recently reserved decision which we covered end-to-end roadblock coverage of the batch of cases, safari retreats, income tax, input tax credit, eligibility when it comes to the construction industry, warehousing industry. He's also recently argued a very big matter on GAR before the Telangana High Court, where the issue at hand is GAR versus SAR, a 4,000 crore issue. In that case, we'll see how that one goes. Make no mistake whatsoever. This case, the MFN case, the Supreme Court judgment, Justice S. Ravindra Bhatt's scholarly judgment, one would say, 59 pages, definitely has laid down the law on tax treaty interpretation. The man singularly responsible, along with, of course, the tax officers who briefed him, that included Mr. Vashni, the man singularly responsible, Additional Solicitor General of India, Mr. N. Venkataraman, is before us. He is going to take over. He'll address us on this important judgment, the ramifications, the analysis, what he argued before the court, what swayed the court in delivering the verdict that it did, and what does it mean? Does it mean the right tax to be paid, as Venkat sir said in an interview yesterday, to money control, or does it mean the rise of unilateralism in taxes, as we are witnessing in several other countries as well? India might not be the only one. We will of course pose questions to sir. We are happy to take as many questions for participants. Venkat sir has agreed to answer them all, to quell any disquiet that may be there among the taxpayer community, to set your anxiety at rest. Please post your questions in the Q&A box, and I'll try to take as many of them and get them answered from Venkat sir. On that note, sir, I cannot thank you enough. Over to you, sir, and absolutely grateful for your time on behalf of all the Taxsutra readers and viewers. Over to you, Venkat sir.
Alasudha Kumbha Vibodha Mudra Vidyavirajat Karvari Apara Karunya Sudambura Shimshi Sharadambam Pranatosmi. Am I audible and visible, Arun? Yes. Good evening, Arun, Kalpana, Taxsutra team, and my dear friends in the profession, colleagues, young chartered accountants, and more importantly, a big namaste to the ministry and ministry officials and the various officers who have joined from across India to participate in this program. A big welcome, and very fortunate to be in the midst of every one of you to address for about 30-40 minutes what this judgment seeks to actually deliver in its real intrinsic sense. Two issues arose for consideration before the Supreme Court. Issue one is when a treaty gets notified under 90, a protocol gets notified under Section 90, and a clause in the protocol which talks about MFN trigger, which is part of the protocol which gets notified. Is it mandatory post the trigger of an MFN benefit available to a treaty partner? Does it necessitate one more third notification under Section 90? Let me put the question as framed by the court and as framed by the assessor. This is exactly what they said. When MFN is part of the protocol, which gets notified, where is the need for it to be notified fresh? This is issue 1. Issue 2 is when countries like Slovenia or Lithuania, when they enter into the treaty, they are not members of the OECD. And say 5 years, 10 years later, they become an OECD member. Whether their subsequent induction into OECD or membership into OECD will trigger the MFN clause for the rest of the treaty partners. So the deciding issue was whether what is relevant for MFN is the date, the status on the date of signing the agreement, or the status when they go and file the return for assessment or seek an assessment with the tax office. These are the 2 broad questions which came up for consideration before the court. 2 separate issues. Both were contested quite heavily, and therefore they had to be delivered. See, when you contest a point, we can't leave it. The court cannot leave it. Revenue cannot leave it. We have to address it. So these were the 2 issues which came up in the batch. It was argued for 4-5 days continuously, and from morning 11 to 4 o'clock. And it was heard by one of the best benches of the Supreme Court, and it was represented by one of the finest counsels for the assessees, rich in their knowledge, caliber, and their effort, and nothing was left undone. Best effort came into. So therefore, the quality of the debate was extremely superior. It was such a treat to be part of this batch and do our best. See, what was argued and what finally got delivered as a judgment. There are 3-4 aspects which, as professionals, as colleagues, as officers who will tomorrow implement it, need to understand. The revenue pitched the case essentially from 3 verticals. The constitutional requirement, the statutory requirement, the global practice, and even the 4th point, what was the practice resorted to from day 1 when it comes to an MFN trigger? Factually proved and not denied. So it is on all these 4 grounds revenue succeed. It's not that you succeed on one point and you lose on another point. So what are the 4 basic threshold grounds for argument? The first argument was, see, we are ultimately, what is supreme in India is not the parliament, it's not the executive, it's not the judiciary. What is supreme in India is the constitution. All of us, including parliament, including judiciary, including executive, including press, including citizens' rights, everything flows from the constitution. What is supreme is constitution. This is sacrosanct for us. Now, constitution, when it comes to treaty making, has involved 2 of the constitutional organs as a 2-step process. The power to negotiate, discuss, and enter into treaty falls within the executive domain. How do we say this? We say this by virtue of Article 73, subclause B. And when it comes to international treaties, it is the central government, the executive, which does it for the whole of India, including the states. States can't enter into international treaties under the Constitution. This 73B is read with entry 14 of List 1 of the Constitution in the 7th schedule, which says, execution of international agreements and contracts, etc., shall be the responsibility of the executive. So this is one side of the picture. Now there is a second half to it. Till such time it is not complete or it doesn't attain fruition. So the second half of the story is the Constitution obligates, by virtue of the second limb of, say, entry 14, list 1 of the 7th schedule, read with Article 253 of the Constitution. It mandates Parliament to implement international treaties and agreements. So there are two limbs to the whole exercise. One is execution of the treaty. Another is implementation of the treaty for it to acquire the status of a law. So we placed before the court, when this is the constitutional mandate, a right for an MFN trigger, is it automatic or does it require the next step of that right crystallizing into a notification so that it is assimilated into the law? This is the fine distinction we brought before the court. And therefore, we took the second step. What is the second step? If you read the Income Tax Act, there are three important sections as far as this case is concerned: Section 4, Section 5, and Section 90. See, all of you know, a charging section is of paramount importance in a tax enactment. It is a non-compromising section, non-negotiable section, because in everything else, ambiguity will go in favor of the revenue. But when it comes to charge, if it fails, then it fails. Everything fails. So charge is sacrosanct. Similarly, the scope, the subject matter of taxation, the field of taxation, the scope of taxation is equally paramount. This is engrafted in the Income Tax Act as Section 4 and Section 5. And interestingly, unlike other enactments, these two sections they condescend by saying this is subject to the other provisions of Income Tax Act, which is unusual. A charging provision will never be subject to some other. But in Income Tax Act, it is mandatory. Why? Because this domestic law is not just domestic law, it also has an international arm, because it also has designed to assimilate DTA benefits to the local, to the residents as well as to the non-residents. So these two sections are subject to Section 90. What Arun was saying, 20 years back, Azadi decided this point. The seed was sown in Azadi, not in MFN. So you go to Section 90, and Section 90 translates the constitutional obligations of entry 14, list 1, 7th schedule, Article 253, Article 73B by saying it shall be notified into a law. Now, as professionals, ask the question to yourself. Can you import a reduced rate of tax, a reduced scope of income automatically? Or should you read it as part of the law for it to become part of the law? You can't apply a DTA without Section 90 route. It's unenforceable. So when you say this was conceded in the court, yes, treaty has to be notified, considered. Protocol has to be notified, considered. But MFN trigger in the date of rate and scope need not be notified because it is automatic. How? Why? How do we meet with the constitutional standards and parameters? See, this is not one law we are deciding. Whatever we decide will have ramification. See, All of you know the Foreign Trade Act allows the import-export policy to be drafted along with the procedures. Now, the assurances given by the Ministry of Commerce in their import-export policy and procedures, unless it translates into a customs notification, it has no force. You can't go and seek a mandamus to enforce an import-export policy. It has been tried and people have failed. So you can't say there is a policy choice already. Give me the benefit of 25% benefit in customs unless it translates into a notification and gets assimilated into the Customs Act. It has no effect. So you can't be so centric in the sense, I'm concerned about income tax, I'm concerned, let the law go to dogs in every other, we are not care. We need this benefit. A court cannot decide it that way under the rule of law. The ramification has to be understood. So the second step which we placed before the court was, please assimilate the constitutional architecture. Please, this has to become part of the statute in terms of a process step which they themselves agree that it needs to be notified for XY, but not for MFN, which is automatic. Why that exception? No reasons are forthcoming. And thirdly, we brought on record and the judgment has captured it even more eloquently and it has added its own value. We should give it to the learned judge for his own research also. It meets with all the benchmark standards of international global practice. That's what, when I wrote the first 1.5 page in Taxsutra, I said, this is a judgment which is in sync with global practices. What has it done? It has referred to Clause Ogle, who is a Dada, who is a very, very respected, distinguished commentator. So can we say Clause Ogle is wrong? If you say the judgment is wrong, you are indirectly saying only that. It refers to Vienna Convention and the subsequent amendments carried out to Article 31. And how it came, the genesis of it has been discussed by the learned judge. On its own, it's a value add by the learned judge. It takes into account the practice by International Court of Justice, which acknowledges how different nations operate under their constitutional schemes and how different nations adapt an international treaty into its genesis as part of its municipal law. It could be referendum. It could be an executive mandate. It could be a special law. It could be a constitutional recognition. These are the types of practices which International Court of Justice has discussed case laws, which has been extracted in the judgment. Therefore, one is the constitutional plank. Second is the statutory plank. Third is the global practices of assimilating the international treaties. And fourth, this is not the first judgment in India in 70 years post-independent to do a revolution to say, no, MFN has to be notified, MFN scope and rate has to be notified, otherwise it's not. No. For 70 years, the law has been in 3 parts, which the judge learned court records in paragraph 44, 8 criteria, which puts the whole historical perspective of international treaty and its assimilation into the municipal. It's in 3 buckets. 1, any international treaty which has an impact on the municipal law and its citizens need to be assimilated through a statutory process because that's a constitutional obligation. And it cites string of authorities. This is not the first judgment. To say that, no, we have been totally unaware for 20 years, you have suddenly brought some new law. No, not at all. If somebody says for 25 years we didn't know, then Well, you have to course correct because they have referred to judgments of 1950s, 60s, 70s, 80s. So if it has an impact on the municipal law and its citizens, it requires a statutory incorporation in whatever form, delegated or plenary, because the obligation under the Constitution gets fulfilled under Article 253, read with entry 14, list 17 schedule only then. It quotes crime law, it quotes environment, it quotes several laws. This is one way of doing it. The second way is the Vishaka type. What is Vishaka type? See, safety to women in workplace. At that point of time, in 25 years back or 30 years back, this came up for discussion. India has not evolved like other parts of the world. So there was no legislation in place. So what did it do? It's not that court did on its own. The Union of India consented with the court. Therefore, it became possible. Vishaka is a unity in thought, both by the judiciary and by the parliament, represented the union, represented by its councils in the Supreme Court. They agreed. Till a law comes into place, let's draft a guideline. Because Supreme Court has its powers under 142. And therefore, see this, what we call it in the constitutional sense, doctrine of occupied field. Till such time a legislation comes, the executive action will have a force of law. Till such time a legislation comes, judiciary can draft. It's not that judiciary is legislating. It lays down guidelines and it translated into law immediately. So we followed international guidelines and framed our own guidelines because we have not had a law of that nature at that point of time. It's the second category. The third category, this very judgment carves out that exception also. If your treaties don't have an impact on the municipal law, nor does it have an impact on its citizens' rights, then it need not be notified. It can merely be an executive action because it doesn't affect the constitutional system. It's outside the constitutional system. It's a contractual obligation qua nations. But if you're going to crack any law and reach out any law for its redressal, then it requires a notification. So, this is not coming up for the first time in MFN judgment. Please don't be under the impression something has happened for the first time contrary to jurisprudence, contrary to law, contrary to all settled practices. Statements after statements are coming. 70 years of law has been reiterated carefully in a nicely planned sequence, that is all. Now, the fourth angle. We did constitution, we did statutory, we did global practice, and we also found how the jurisprudence has evolved. Fourth. Now, the fifth angle is we showed on record that the practice of triggering of an MFN is once there is an MFN availability to a nation, nations sit, discuss, and decide what they want. Because it can trigger a scope, it can trigger a rate, and it is up to the negotiating parties to reach how far they should reach on scope, how far they should reach on rate. We showed such exchange of correspondence from 1993. Not in 2018, 2012, 2010, 2020, nothing. 30 years this has been happening. If people are not privy to this information and they make their own assumptions, what are we to do? So, 30 years of consistent practice is alone followed this time. So the question is, when nations themselves have come out and discussed after the trigger or based on the trigger, and they have negotiated. Some have negotiated on scope, some have negotiated on rates. Both may be available. They may opt for one, they may not opt for the other. We showed it in one of the treaties. See, both are available in terms of the MFN, but they have the whole negotiation has only been on one, not on the other. Wide exchange of correspondence between the diplomats of the two nations. So this is the standard practice. So why should in 2023 this practice be thrown out to the winds and a new law to be laid down because this is what we perceive the law to be? Is the question which as professionals you should all answer. See, we are bound by rule of law. We can't have one law for income tax and another law for the rest of the laws. When it comes to international treaty, especially, see, we are entering into series of FTAs. We are entering into, it's not just FTA or BIT or DTA. Every ministry is now getting into international engagements. May it be telecom, may it be broadcasting, may it be several aspects. One of the few days back, there was a case on convention on seeds and fruits. We have a treaty. How many of you are aware of? So can we say, no, Parliament need not do anything because MFN judgment says so? Can we do that as a democratic nation, accountable to its people? So the bandwidth perspective has to first reach us when we deal with such subjects. See, we deal it in one kaleidoscope and see the world in one way and say, this is the world I see, and this is the end of the world. Whereas the conspectus is too huge, humongous to deal with. So this is one issue. These are the steps in which it got decided. I am ready to take any question after this. I'll finish the other piece also. Please tell where we went wrong. I want to learn. Because stalwarts argued, it's not that their efforts were less, any less. Brilliant arguments were made. So this is part one, as far as why it needs to be notified. Now come to the second limb. Second limb is even more interesting and less challenging according to us. See, we showed, it's recorded in the judgment also. You take Switzerland or Netherlands or France or OECD countries and the investments that flow. And the investment which we have contracted with Slovenia or Lithuania. So when we enter into agreement, they are non-OECD members. So we argued only 2 points. We said, when somebody is not a member, the executive under the Constitution, under Article 73B, has got the discretion to go and negotiate because it's not an OECD member at that point of time. So when it's not a member of OECD at that point of time, it wants to give X benefit, it wants to give Y benefit because it is not a member. Now, 2, you are constitutionally crippling the negotiating power of the executive when it's negotiating with a non-OECD, if this interpretation has to be accepted. Why? Because, see, we give a lot of SOPs, we give a lot of benefits only because it is not an OECD member at that point of time. Our negotiating skills, our negotiating bargaining powers are extremely different with those countries. So, anticipating that they will become OECD, you should now negotiate if you're going to draw a law in anticipation. This interferes with the constitutional right of the executive arm of the government in discharging its constitutional obligation in a fair and a distributive manner. What's the second point we argue? One, you are actually crippling the power, which is not there. And 2, you are interfering with the constitutional discretion of policy making, choice. The court said, yes. And the third aspect which they argued, it should be the date of assessment. It doesn't flow from anywhere. It's just a figment of their own imagination. And to say that this is how we have conceived the law, the conception is wrong. So it can't be the assessment, the date of assessment which will be relevant to trigger whether you are OECD or not. Where do we get it? to read the expression is a member of to that extent. The court said it is far-reaching and overarching. We can't do that. We are helpless. We can't do that. So, this is the second limb of the judgment. Now, 2-3 things I want to conclude and take up questions. I would request all of you to, if possible, read the whole judgment. If not, read paragraph 44. Whatever has been said now has been condensed into 7 short paragraphs in para 44. We have not spoken a word more than what is flowing from the judgment. We are not speaking our written submissions. We are speaking what the judgment seeks to say. And para 44 houses these parameters which we have now discussed. Now, 2 things, and the last one, in the last 5 minutes, then I'll take questions. Now, the lot was said that, look here, I have given my right, which is a premier right of my nation. And therefore, it was given in good faith that you will back me up in MF. Therefore, you must go with a textual interpretation. See, we argued all this. It was very interesting. That 1.5 days was very interesting out of the 5-6 days of argument. What is textual interpretation? What is contextual interpretation? What is unilateral interpretation? What is bilateral interpretation? What is dynamic interpretation? See, they all showed letters. See, our signatory and partner country is saying this. We showed from international authorities, commentators who says, in a bilateral agreement, if unilaterally somebody starts writing, then the man who does it first has the first preference. He can write whatever he wants to say that this is my understanding. So, unilateralism superimposed in bilateral contracts is unacceptable. And therefore, all these letters did not stand the scrutiny because it contravened the earlier practice of 30 years of negotiating. And this unilateralism is unacceptable in a bilateral contract. Globally, we cited from global commentary, not a local judgment. Because you will all feel, no, it's an international thing only. Everything is grounded on international principle. I can say this with a lot of conviction and with a sense of responsibility. That's why we espouse this judgment is in sync with global practices. India has matured. Indian Supreme Court has reached that zenith by trying to talk the language of other nations and say that this is also India wants to speak at the moment. It's a triumph to our Indian judicial system. We should welcome it so that everybody understands. See, you want uniformity in law. You want uniformity in the interpretation of conventions and treaties. When there's a uniformity, then why should we resist? Why should we say, no, it's still against me? See, this change in the contradiction is confusing. How do we, in law, assimilate it as a point which is in your favor? That's the question you need to ponder upon. Therefore, when they said text and context and good faith, the simple question we asked was, you say you have given some of your powers, which is of national importance to you. Even after 4 years, when we write and use this very clause and say, give me these details, not a scrap of paper comes. Because you have created a system in the municipal law, which is impossible to crack to get that information, even though treaty says information will be given. So the question is, what happens to good faith there? Take software. Matter is, of course, under review. When South Africa and Australia, which are OECD countries, can depart to serve their interest, what happens to 26? What happens to 31 for them? So, when there is a compulsion, this is not a judgment of any such compulsion. It is in sync with international practice. I'm only saying an extreme view is also emerging in the world. This judgment has not moved into that terrain at all because it is in sync with global practices. But you must understand the behavioral pattern when it comes to interpreting treaty. Each country has its choice in spite of being a signatory. It may be few, it may be many. Doesn't matter. But departures are departures to be recognized. So 26 or 31 ultimately has its own dynamic interpretation depending upon the surrounding facts. There cannot be one strict, one size fit all interpretation in an international treaty. It's not possible. It has to be extremely contextual. It has to be situational. It has to be, because ultimately it's negotiation, it's bargain. So these are the frills. There are many, but given the time and option, and I want to take questions rather than keep speaking about it much. So this 40 minutes, whatever little we could endeavor, we could do in 4 or 5 days of long hearings and very detailed. Several pages of written submissions were filed by all the parties. It has all been assimilated and put it in a 59-page beautiful judgment. Let's give the credit to the court and let's give credit to our Supreme Court for what it has done, whether you like it or not personally. Thanks once again to everyone for patiently staying in this discussion and listening. Thanks, Arun. Thanks, Taxsutra. Thanks to all my colleagues and also to the ministry officials and the officers of the tax department. Namaste.
So can we take questions now?
Yeah, that's true.
There are at least a dozen. I'll try to take as many as possible. This is from Naresh Makijani. A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose, as per Article 31 of the Vienna Convention. Sir, in your esteemed view, does the ruling consider the said article in its entirety?
More than its entirety. It captures the history. It captures what ran in the author's mind. The author who drafted 31, it refers to the author's name and says what he thought initially and how he benchmarked. In fact, I will just 1 minute, if I can find that out. I somewhere noted it. I'll just see whether I can. The three, yeah. Yeah, para? 73, take that. He puts what were the initial expressions used and how this has articulated into a larger expansive definition. So it is in consonance and spirit after factoring beautifully the evolution of Article 31. That is clause of will. No, in the VCLT, the first 3 expressions originally used and then subsequently amended. See, subsequent amendment I have, original I don't have. Okay. Subsequent agreement, subsequent practice, and relevant rules of international law applicable in relation to parties. And subsequent practice to include executive, legislative, judicials, or other functions. And it refers to ICJ practice on good faith. And how ICJ recognizes every state's assimilative process as a valid process. So answer to the question is well described in the judgment. Wholesome.
Yeah. Next one, sir. This is from Jagat Mehta. A bit provoking, but yeah, I'll take it. Sir, with due respect to Honorable Supreme Court judgment, if the second nation needs to be specifically notified, then what is the use of the MFN clause in the DTA? I understand that till date, India has not notified any DTA for the purpose of MFN clause. And does it seem that MFN has no operation at all?
See, what we argued, in fact, they also argued, we relied on the same set. We showed different texts, different language used in India, Finland, India, Poland, India, Vietnam. All that we showed, different countries. I don't remember the names exactly. And we persuaded the court to understand each country has a set of political governance. And each country wants a particular language to suit the negotiating power of MFN when the trigger happens. That is how it's all minuted. So what you do, you agree for an MFN trigger, a right, you secure the right, but subject to negotiation, subject to discussion, subject to deciding what should be its rate, all that. So it is in two parts. The different languages used in treaties, it is recorded in the judgment also. They, based on the treaty partners' political governance and the treaty partners' requirement, we have changed. It's not that we do for one in diplomatic, one for discussion, one for post. No, it's all the same from India. It's we suit the partner's requirement. Therefore, this has to be understood that way. And the court went on to appreciate it in our favor. Because we can't discriminate between one MFN and another MFN. That's not our, it's not within our, it is not within the executive reach or the Ministry of Finance reach to do that. We have to treat everybody uniformly. Yeah. Arun, I'm not able to.
Yeah. So there are at least 3 attendees who are asking this question. Why was the India-Spain DTA matter detagged or deferred?
I think all the respective DTAs were represented by councils. India, Spain, there was no representative council from. So I thought the court said we should give them an opportunity. It was more to ensure that they are not, they don't get decided behind one's back. That was the reason. I think it's
okay.
Because everybody argued to the heart's content. Nobody felt we have not been heard in this matter.
Yeah. Sir, and in case anyone missed the arguments, they are there on Taxsutra, all days. Yeah. This question is from Kavita. She asks, is the ruling applicable retrospectively?
Oh, yeah. I think it's, I don't know whether she's a chartered accountant or a lawyer, doesn't matter. See, a law laid down operates from the date of the law. Unless otherwise, Supreme Court uses its power under 142 to say it is prospective overruling, which it has not exercised that power, nor was it sought by the assessees. So 142 has not been invoked, therefore it dates back to the respective agreements. So it is not retrospective. A law as interpreted will date back to that particular law from the date of that law. That's the principle. Unless otherwise it is overruled prospective.
Yeah, this is from Sachin Sastakar. Sachin asks, essentially saying that if, so in terms of the treaty and notification, are we in default? They're saying, can the taxpayer hold the government to be in default if the promise given by union is not converted in the law of the country by notification?
There is no estoppel against plenary legislations. Very important. You can't plead estoppel against parliament. These are all well settled. These are all internationally acceptable principles. So you can't hold a plenary power to accountability to say that no, you have said this, you have not said this. It is a freedom of the plenary power, and therefore you should have organized your business based on the law as is prevalent. And 70 years of, see, this is not a new invention. Any assumption to that extent has to be reevaluated. It's an existing law which has been reiterated in income tax law. That's all.
Yeah. So this is a very interesting question by a good friend from Bangalore, Akela Prakasarao. He asks, sir, what are the meritorious arguments that were brought forth on the side of the assessees?
No, for everything they contested. See, I mean, I don't want to be very selective. Every council was sparkling and they were doing their very, very best. Oh my God, the kind of passion. See, I've been an assessee council. I know what it is. So the kind of passion they carried, the kind of conviction, and it was sometimes quite hot, quite sarcastic, but it's all in the game. No ill feelings. So it had a mix of everything. It was a mix of fun, sarcasm, temperamental issues. Everything happened in 6 days. But the moment the case that day's hearing is over, we used to put our hands over the rest. And that's the committee we maintained throughout the hearing. And more importantly, the learned court was completely unruffled. It just was a witness. it picked up just what we argued in law and decided the case. It was an interesting experience that day.
Again, a provocative question. Nidhu Malhotra asks, sir, can this decision go a step further to suggest that any notification issued under Section 90 will override the treaty?
No, it's not a question of overriding. I think that is a mistake. A treaty content and spirit as entered by the executive is given a legislative status under the constitution by its assimilation through a notification. It's a process. It's not overriding. That's a wrong understanding.
Okay. I'm trying to... A couple of participants have asked this question. Dheeraj says, can we file a writ before High Court to compel the government to issue a notification importing the MFN clause from subsequent beneficial treaty?
We are already arguing such cases in the anti-dumping duty matters. The law is fairly well settled. See, under the constitution, policy-making choice is the discretion of the central government. And enacting the law is the discretion of the parliament. So a court can interpret law. A court cannot force either the central government or the parliament or the state assembly to say, I issue a mandamus for you to draft this law. Not possible. That's why I singled out Vishaka. Vishaka is a case where the union agreed with the court that we need a guideline till the law comes into place. Therefore, a guideline was laid down. So, there can never be a mandamus which will issue against parliament or against government to say, this should be a policy. See, in a democracy, ultimately the choice is because of the governance which has come to power out of winning elections. In fact, when somebody was saying yesterday, I'm so unhappy, so irritated, my dreams have gone, he was saying so many things, then I said, I should only say, if you still feel what you feel is right has to become law, then you should stand up, contest for election. In democracy, it's permissible. Contest election, become a policy maker, become a minister and draft the law. You have the choice. Till such time, your aspiration has to be in sync with whatever is the law as decided by the courts.
The Supreme Court may be fallible, but it's final. So we all should remember that. Here is a question from our good friend Ajay. He says, how would the MLI be read in light of this judgment? While the Indian government has approved the ratification of MLI instrument, how each bilateral treaty changes due to MLI is also dependent on options selected by treaty partner. It can be said that in effect the treaties are amended. Should there be a notification for every such effective amendment?
It can be everyone, or it can be together. See, these are all only style of legislations. Government is also working on it. Let me come back on that in a more articulate way when we come finally with that picture. Yeah, sure. See, this is a law. We can't say that we will also not, when you have to follow the law, we'll have to also follow the law. It can't be different for different people. Yeah.
Mm-hmm. A couple of people asking this question, Ramanujam, Srinivasan and Samir Shah, can MAP provisions be invoked by treaty partner?
If it is otherwise permissible under the treaty for you, see, this judgment has not got into the right of MAP or the right of interference. From what little I have argued for the assessees at that point of time, MAP is an alternative mechanism which does not in any manner hit or affect your right of adjudication. So that right stands preserved. If bilaterally we have agreed for that and it gets notified.
Yeah. So there are a slew of questions from Charanpreet Singh. I'll take one. Since he's taken the effort to type so many questions. There was not just one judgment of Delhi High Court. There was one from Karnataka High Court as well. Taxpayers had full right to rely on the High Court judgments. On the implementation part of judgment, what is the view? Whether it be prospective or whether interest penalties can be relieved, considering the practice which majority of taxpayers were following.
See, interpretative issues, leniency is always one of the guidelines. So I think it's a policy call. We'll come back on that. But it has been a matter of judgments both ways. So we need to be, payment of taxes is non-negotiable. The rest is all something which a policy call has to be taken by the government. We'll also try to give our inputs to that extent.
Yeah. So this question is from Sudarshan Rangan, I think from Chennai. Sir, an academic question on international law jurisprudence. Was there any reference to Article 27 of the Vienna Convention, where it stipulates that a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty?
No, we could not have, nobody could have invoked 27 because Indian law and the Indian constitutional obligation are to the contrary. So you see, an executive arm of the government has no right to say, I will not implement law. My parliament will not pass law, we will negotiate. Can executive arm say? And there is a constitutional mandate. Therefore, 27 under the Indian constitutional scenario could not have been pressed by either of the sides.
Yeah. So can we take one more?
Yeah.
We have several, but I'll restrict it to another one. I'm just thinking which to pick.
You pick anything you want. We'll try. If I know the answer, I'll certainly say.
Okay, yeah. This is from Yogesh. Section 91 states that government may enter into an agreement with another country and may issue a notification for implementing the treaty. However, 92 states that once the government has entered into an agreement as per 91, the beneficial provisions of treaty will apply. If 92 gets triggered immediately, once the government enters into a treaty, is a notification still required to claim benefit under 92?
That's the point on which we succeeded and we scored. See, because 92 is a window available for every assessee, domestic or non-resident, to claim a better benefit between a treaty and a domestic law. You have a comparison in terms of scope and in terms of rate. So unless it acquires statutory status under a constitutional mandate, how does it become enforceable? That's the point. What you have asked is the point. That's the clear essence of what was argued. Can you see, you forget DTA. Can you give income tax rates without notifying it in the parliament, in the budget? Can an honorable minister or can a senior officer of the government, bureaucrat say, this is the rate from tomorrow, all of you will follow? Will you not file a writ petition the next day? Saying that, where have you brought the amendment? Will you do it or not? So, when we say that that is the law for a treaty, why there is an opposition for that? Is the question.
So very, this is my favorite question. Neetu Gupta asks, had you been arguing on behalf of assessees, what would you have argued different?
Let me do that when they become again an assessee council, not now.
Yeah, we need some humor as well. Thanks, Neetu. That was a wonderful. I would have asked that to sir as well. What would he have argued differently? Yeah, if I were to continue to take questions, I think we'll go past 8 o'clock. So we'll close the session for now. So, as a moderator's perk, let the final question belong to me. Any particular reason, sir, you think this judgment was so controversial? It has become suddenly, there's been such a big outcry on this one, number one. So, number two, this is from me. Is there any dichotomy between the government stand in the software review matter, where you are saying that the OECD text or treaty is not the Bible, and here you've gone so on to say that no, this judgment follows global best practices? Is there some dichotomy, sir, between the stand in the engineering review and this matter?
My God, anyhow, I'll answer both. See, it's a good question. I hope I can take a few minutes to answer that.
Please, sir, please.
Important. I'll take the second question first. See, somebody also said, I read only something came that there is a rift in the government between the law officer and the revenue secretary. Fortunately, media did not pick it up because it's preposterous. See, please understand. A law officer's role is very limited with the government. I want my friends to really understand. Don't think we can do. We can know. See, you are a lawyer or you are a chartered accountant. Can you exceed the brief of your client? Can you write down your client? Will you do it? You can't do it. When you can't do it qua a particular assessee in its private capacity, do you think a law officer can override and override the government and do whatever he likes? Is it possible in a system? In a big, big system where there are several filters, several checks and balances. One. And two, you must know how things are discussed. See, if this question of software is put saying, you mean to say the international taxation wing is overlooked? Do you mean to say the revenue secretary who takes a final call is overlooked? Do you mean to say that finally this reaches the honorable minister because it has an implication? They are overlooked, that an officer can do whatever he likes. How is it possible? See, and personally as a law officer, I have to tell you this committed, I will either as an assessee counsel or as a government counsel, I will never ever exceed the brief of the client. And when you work with government, they are policy makers, unlike private assessees. Tomorrow, if government says, no, we will not pursue this review for some reason, do you think court will say, no, we have filed a review, we will discuss? Can judiciary do it? Can a law officer go and say, no, irrespective of what government has taken a stand, no, I have prepared it for 3 years, I have to argue. Can I argue? So these are absolutely impossible things to conceive. And you cannot file anything, at least I don't file anything on my own without taking, no law officer will take the chance. Take it from me. When you work with government, everything will be on record. And only when government allows you to do something, we as law officers will act according to the client's instructions. We don't have any independent powers, nor will we try to exercise that independent powers. Nobody will dare to do it with government. So it's something wrong. Now coming to the first question, I think this is more to do with also the telecom dispute and several other disputes. So I'll take 2 minutes. I want, if there are youngsters listening to this talk, it is something which I'm requesting youngsters to mull over and think. See, I am a law officer for the past 3-4 years. And I've been an assessee counsel for 3 decades. And I've worked with all the law firms and all the big fours and all equivalent law officers. The culture we had in 2004, the culture we had in 2014, and the culture we have in 2023 has undergone a full toss. Take it from me. I say this as an elder brother to all of you. And I'm making a passionate request to my friends who are all youngsters. See, you are all now cutting edges in the sense, in the name of competition, and clients are also should not do this for you. Now you are trying to see how you can cut and make a better opinion than the other so that you can compete in the race, how you can impress the client. So your focus is not on law. Your focus is not on jurisprudence. Your focus is not on how it will get decided after 10 years. See, political shrewdness, bureaucratic pragmatism, all this I've learned it in 4 years. I'm sharing this with concern to all my friends. They're all extremely dynamic in nature. And every 10 years, Supreme Court also, courts, see, today, you're all thinking it is no longer easy to win a case for revenue. I've been saying this again and again. Because so many young judges have joined the judiciary across India. And judges of the Supreme Court who have elevated from the High Court, they have completely different thinking. They don't believe in stakes. They don't believe that revenue can always be right. So you are actually put on a guillotine every time. You have to fight your way to win a case. It's not easy. So, and if you still lose cases, please, at least for future, be very careful when you decide an opinion. This is the instruction. This is what my senior has taught me, which I'm sharing to all of you. Never give an opinion based on a judgment. Please. Read the law. Interpret the law with your professional expertise, with the guidance of your senior, etc. And verify whether the judgment is in sync with this interpretation. First, interpret it independently. Don't be guided by, in a court case, when you fight, you can rely on judgment as precedence. When you dictate an opinion, when you advise a client, don't be guided just by judgments. They will stay here, they will not stay tomorrow. But law will stay, and interpretive power of judiciary will stay. So that is why you are engaged. So it involves a lot of trust. It involves a lot of commitment. It involves non-compromising attitude to serve the client's best interest. You have no right. None of us have a right to sit. We can't use clients as a horse here for us to ride our battle. Never ever do it as youngsters. It's a request. None of us can do it. We have not done it in our lives. In fact, I will add one question myself, because now when you win all these types of judgments, people who care for me do say, hey, come on, yeah, there is a market news that you have become anti-MNC. We can't become, see, government today, no government in this world can afford to be pro-MNC or anti-MNC, pro-domestic, and world is all one baggage. Okay. Every call we take a call in the best interest of industry. When your interpretation, all the time testing every time is, you take this telecom judgment, you take any judgment, if we have one, tell us where we have gone wrong in law. Your articulation is it's against our expectation. It's against our interest. It's against our opinion. It's against our practice.
Can I flip it, sir? Can I flip it? I want to be a bit argumentative, sir, with your permission. So, these were 50-50 cases, one would have thought. In both of them, the Delhi High Court was in favor of the taxpayer. In fact, the Delhi High Court judgment was delivered by Justice Sanjeev Khanna in the Capital versus Revenue matter, who is now sitting on the Supreme Court, who is slated to be one of the Chief Justices in the next 2 years. So, these were two Delhi High Court judgments, which have been subsequently, reversed by Revenue. And in both the cases, one would have thought dispassionately, as Taxsutra or as a journalist having covered both the cases, that both were 50-50 matters. Wouldn't you have thought so, sir?
I'll answer this. Now, you heard me for 45 minutes, and 300, 400 people heard it for 45 minutes. I want them to write or put it in Taxsutra how this articulation in law is wrong. Forget your emotions. I want to test it. You have to test it under rule of law. Now, coming to the telco judgment, indeed, the author of the judgment in the Delhi High Court is a trained, well-known, extremely neutral, passionate tax judge. But what we showed to the Supreme Court was only this. The court was not assisted fully in the Delhi High Court. Otherwise, whatever we have argued before Supreme Court, had we argued before the Supreme Court, before the Delhi High Court, the articulation and the outcome could have been different. You are saying 50-50. Why? Because, I'll give you one example. We showed to the court 5 provisions from the Telegraphic Act and said that, please test. The parent license is under the Telegraphic Act. If you read these 5 provisions, whether this payment is made towards license or payment is made for anything else, if you don't make a payment even for 1 day, your business under the Telegraph Act becomes illegal. That's what the Act says. Unfortunately, the entire provisions of Telegraph Act was not even placed before the Delhi High Court. So, a judge can deliver a judgment based on what is articulated. If you don't aid or assist the court fully, you can't blame the judge or the court here. And you can't blame the revenue for succeeding also. Now tell us, we showed 3 Supreme Court judgments which made a distinction. The test for capital versus revenue is whether you make the payment in one shot or you make the payment in installments. If the payment is traceable to an acquisition of a right which sustains you as your life breath, then it is capital. This license fee, whether you pay it on day 1 or on the 20th year or an installment, can you do this business without 1 day's payment? It's a question we asked, because that's the question Supreme Court asked. So manner of payment is not determinative. One last minute. Under the Income Tax Act, there are 3 verticals we showed. 32 is for depreciation. Then there is a provision for amortization. And the same capital versus revenue, there is a provision for 100% write-off for pre-trade expenses. So when you have 3 isolated verticals and spectrum and telecom license are covered under amortization, if you choose to do 100% write-off and claim it as that, how is it? It's plain language of the law. This is all these 3 were not shown to the Delhi High Court. See, whatever has been articulated in the judgment, the court was not assisted fully. We can't say a best of judgment comes from. That's why I say MFN is a good judgment, because the best of points were argued by the assessee counsel. You cannot find fault with them. None of my friends have argued less. You should give it to them. And we still succeeded. So the quality of the judgment remains superior. So this is how you should understand the judgments, and don't mistake for that.
So the toughest question is reserved for the last, always. So in the 3 years that, and this is a sitter, it's a full toss which you have to throw it out of the park. In the 3 years, so you argued several landmark cases. You won many, some have gone against you. So which one has given you the most personal satisfaction while arguing?
See, every big case, every batch case, I have argued against minimum 4 senior counsels to 12 senior counsels on the other side. And all of them are my friends. And some counsels who are not senior counsels by designation, but by senior in terms of knowledge and intellect. So whenever you argue a big bandwidth of senior counsels on an important issue, those days, those moments are indeed priceless, unmatchable moments in my professional life. May it be BKC, may it be Mohit Minerals, may it be charitable, may it be MFN, may it be Safari. I can't distinguish one judgment from the other. Outcome is not in our hands. But the kind of effort each one puts to defend their case. See, all of you only listen to a judgment. Most of you don't see what happens in the court. Oh, in Mohit Minerals, it was 12 seniors who argued against me. So it's a divine opportunity. It's a great opportunity. I'm thankful to the government. I'm thankful to the ministry. I'm thankful to everybody who's supporting us. So we'll do our best. And this has nothing to do with, see, the ethics are the same. Whether you argue for government or you should be very committed. You should be very, very trustworthy. You should not compromise on your integrity. And you should not ride on your client. If you have these 4, work will come to you, whichever side you argue.
For the last 70 minutes, you listen to the man, a one-man army, we should call, who's been taking on a slew of senior counsels on the other side, and successfully so in several matters. The revenue is on a juggernaut, is on a roll in many high-profile tax matters. The man responsible for it, you heard him for the last 70 minutes. Additional Solicitor General N. Venkataraman. Sir, I cannot thank you enough. There are so many who have written, who have messaged asking me to thank you, including officers who assisted you in this matter. Many thanks, sir, for this 70-minute exposition and patiently answering all the questions. That patience is tested in court, I'm sure. It is tested also at times during such webinars. Profuse thanks, sir, and thanks to everyone in the audience.
I thank again, I failed to thank Kamlesh, I failed to thank Chetan Rao, and the young Sugat, and one more lady. They're all people who work. It's a team effort. Without government support, without so much of interaction, this is not possible. So I thank all of them. I thank all the officers who are heard. And my dear young friends, I'm always available to you. Be very good in your, be articulate in your opinions, but don't be swayed with competition. Don't be swayed with catching business. You will miss your targets. Ultimately client pays us, and we are answerable to the client. So don't move away from this arc. It's a request to youngsters, not for old people. They know what to do. To youngsters, it's a request to all of you. Thank you so much for your opportunity.
Thank you so much, sir. Final words. Thank you so much. Thank you.
Thank you.
Thank you.
Can I exit?
Yes, sir.